people who ask me, well, what happens if I don't have a will? Does everything go to the state? And that's really not true. That's a misnomer. The court will appoint an administrator over your estate, and there's a procedure for that and a consideration for that. Very often, in a situation where there isn't a will, somebody will step up and say, I will take over and do those duties, and we don't have a dispute about it. But if there is a dispute, there's a mechanism in the court to resolve it. And then your estate will be administered and distributed in accordance with a statute that Pennsylvania has, an intestate, they call it intestate statute, which just really provides how your estate will be managed and administered, who will be able to step forward and receive the proceeds of your estate after those costs have been paid. And what I find is that while sometimes that will flow in the very same way that you might have wanted it to flow and dictated it to flow, very often it doesn't. There are special rules and consideration for whether the decedent has a spouse, has children, are those children of the spouse, are they of a previous spouse? And the complexities of that and the considerations of that when we talk about a blended family get kind of dicey and often don't result in the outcome that the decedent would want. And I think that's unfortunate. I think that's unfortunate in many ways that are obvious. But I think one of the things I would point out is people who I see getting into those situations are oftentimes waiting too long to put their mind to the task of establishing an estate plan. In fact, I think the key times where you need an estate plan is when you are young and start to have a family, and then as you get to your middle age and things have now become more complicated, and maybe there are considerations, like I said, about how you want that end stage to go. And then when you're older, to update it and make sure that it still follows through the way you want. So it kind of goes to some of the final points I'm going to be making about don't wait, don't hesitate, don't think that the state will provide the answer or solution for you because it may not work out the way you want. But now we're going to shift, because the other two documents that I think are extremely important are, first, a financial power of attorney, and this is going to allow the financial affairs that you need to be carried through to be conducted in your either direction because you're not able to get out and get to them, or if you are incapacitated, cannot communicate, somebody can still act for you and act on your best behalf. So some people come to me and they think, well, my spouse can do all that for me, right? And in many cases they can, especially if you set up your financial affairs where there are joint ownerships to accounts and so forth. But sometimes you will not be able to have your spouse carry out all those affairs without having an actual power of attorney in place. So it's an important document even in considerations where there are spouses and things are together in terms of ownership. But the first thing you want to think about is, the granting of the powers, and those powers can be wide-ranging and attend to all kinds of financial matters. And you can also authorize your agent, in this case, we call it the agent of your financial power of attorney, to act on your behalf even when you are incapacitated. So some people are concerned about giving such broad powers to people, about what might happen, but you should understand that your agents are required to first acknowledge that they will carry out these duties for you. That is a requirement of the law before those actual powers can be used. And so they'll sign off on it and acknowledge that. There's a statement that they acknowledge that they will do all things either by your direction or in consideration to what you want in terms of your best interest. So they got to act on your best interest. They just can't start gifting all their money to you, to their friends and so forth. They have to act in your best interest. And what's nice about these powers is that they are allowed to act without any further court consideration. If you don't have powers of attorney and you don't have the ability to have somebody act on your behalf, then you have to go through a court process to have somebody appointed to be your guardian now, and that will delay those affairs being attended to and may not result in the right person or the person you want being there attending to all of that. So the key questions that we have for our powers of attorney are who will be our agent, and if they cannot act, who will be your alternate. Again, I like to put a little longevity into my plans wherever possible, so those considerations give it a little more life to it, allow it to be put into place, and then you can know that you have the right people in place, even if there is an agent that has to step away or can't act or predeceases you. The powers that you grant can be either immediate and durable, which is primarily what I set up, especially for husband and wife. And then it can also be set up to only arise when you become incapacitated. The only hesitation I have with that is that somebody has to adjudicate you incapacitated enough so that the powers then do, as we say, spring to life. But that is a consideration that you might have if you're ultimately concerned about putting that power in the hands of somebody immediately. And then the powers that you grant can be prescribed. There's a long list, and it's too long to discuss today, but they really cover everything and anything you could possibly do for yourself. You're now deciding whether or not you want somebody to act in that same capacity, or do you want to limit it in some way, like maybe prescribe that they can't sell your real estate or do something like that. But the next document we're going to consider here is a healthcare power of attorney. And now we're shifting to the medical care. And this document really is a document that spans the entire continuum of our care, from small, minor episodes where you might have a condition that requires you to go to the hospital, you're not able to fully articulate what you want done. Your agent can step in and direct what kind of care you get, direct where you go to get that care, and then as you recover from that and go back home, you resume your own personal oversight to your care. And it allows them to get into medical records, it allows them to get into the financial aspects of your actual care too. And there are a lot of overlaps here. I know Ken last week spoke at length about some of these issues. In common parlance, we sometimes refer to considerations in this area as advanced healthcare directives, as living wills, and so forth. The state of Pennsylvania about 10 years ago enacted another statute that allows for these powers to be put into the place or the hands or the charge of an agent. And I champion and want everybody to have at least one of those documents in some form or fashion. But if you really are looking at your life and seeing where you might have those episodes, where you might have further complications about how and when things are to be done for you, a medical or a healthcare power of attorney might serve you better. So that's one of the things I want you to consider. Here in a medical power of attorney, you're going to have an agent who will be able to get into those records. There are end-of-life considerations. The state of Pennsylvania promulgated a form for this, and there are end-of-life considerations also in that format. And so the key considerations for this would be, who will be my agent, my healthcare agent? Can they, if they cannot act, who will be the alternate for this? And I think there's also places in here that you can make special considerations. You can indicate things like your family spread out all over the country, let's say, and you want them all to be able, they've discussed with you and indicated to you that they all want to be present if we're going to go through one of these, let's say, end-of-life scenarios where prior to turning everything off, they want to be in the room with you. Well, giving them a few days to get there and be present and so forth can be provided for under special considerations in this regard, and other concerns, like if you want certain religious rights, actually over you before your passing by a very specific person, you can indicate that too. We never want to make it too complicated. I think the doctors in the room would agree that these end-of-life decisions, once that consideration's been made, that there's nothing more they can do. They do want you, if you have indicated so, to pass naturally and quickly, and so we don't want an extended period of time. But some people come to me and have concerns that can maybe be accommodated by that document. And once we get into the nitty-gritty of it and we get past sort of the recover and go home considerations where there is no further chance of recovery, you can prescribe the form and the methods of care that you want, either sustained or stopped. And your agent can be either bound by those decisions or use them as guidance. You can dictate one way or the other. But where we bind our agents to it, now they're really just in the role of informing the doctors that you have made these decisions and to carry out that plan just as you have directed. There's also room in the state format for other considerations like being an organ donor that you can also address. And I know a lot of us, a lot of my clients chuckle when we get to that question because they think they're too old and everything's all worn out and who wants any of this stuff. But you would be surprised. Again, I think the doctors in the room would tell you there is a lot that can be done. And so, but it is a personal decision and we leave that up to our clients. Now, the next steps that I'm gonna I think you should have a relationship with your legal advisor, your attorney. You should start that. I know a lot of people don't like to go talking to lawyers. It's too expensive. It's only for the bad stuff. But this is a good conversation to have. This is a good conversation that you do want to get into so that you can get your questions answered about what your plan might mean. You can make a list of those and go off and talk to your attorney. We're going to leave a little worksheet for you to consider. It'll be a little handout if you want to take it along. We made a few copies. If you don't get a copy of that, you can just go to the atonement directory and find me and call me up and I'll email it out to you. And so we'll make sure that that gets to everyone. And then this relationship you have with your attorney can be beneficial also for other reasons because you're specifically talking about that plan with him or her, and you want to then ensure that by having that conversation, they can continue to inform your executors and your beneficiaries as to what your thoughts were, why the considerations you made are there. They'll have notes to it so that, again, we take the stress out of that as it happens as they move into an estate. So finally, or I guess I have another slide here, I want to address what happens when someone does in fact pass. I get a lot of calls and there's a lot of confusion about this. First and foremost, I always tell my clients and the people who call me, they need to first focus on the funeral of the individual and on the family. Take care of those things first. That's the most important thing you can do. The estate and the opening of the estate and the carrying out of the wishes within the estate can only really happen after the funeral. At the end of the funeral director will prepare death certificates, and I need those death certificates along with some other information to actually open the estate. So I think what you want to do is you want to contact the attorney that you're working with, inform them that this has happened, and they will give you advice on what to do. Sometimes people come in from out of state and you know that there's something they're specifically supposed to get, and you should work with the attorney and get the advice of an attorney about that before you start moving everything around. I have had estates be presented to me where everything has gone to the four corners of the United States, and now we play a lot of catch up, and it just really increases the cost of the estate when we have to do that. So hold tight and talk to your attorney. That way you'll get the right information and take the steps at the right time. And then finally, I've been talking about this already, contact your attorney. Most attorneys can prepare a basic estate plan, which would be your will, your powers of attorney that we talked about. And I would tell you that most people will not need advanced estate planning. There are many advertisements we might see, many things out there about how to avoid this or preserve that. And I don't want to get into individuals or techniques, but I always advise my clients that when they hear things like that, It sounds good, but at the end of the day, you really have to go back and talk to your attorney, talk to your doctors, talk to your financial advisors, and really make sure that what comes out of that more advanced plan, where we maybe are using a trust or some other kind of mechanism there, really is going to get you the results you're looking for. I've seen many people go astray and end up spending and wasting a lot of money only to come back to needing a will again and administering their estate through a will. So once the documents are in place, most attorneys will make it very convenient and easy for you to come back and make changes to those plans because it's all held electronically in our systems. We just go in, we make a few updates, and it is not a very costly thing to have to do. So having said that, are there any questions that you might have with regards to the presentation? Yes. Mm-hmm.
I have someone else as my healthcare and my financial power of attorney, but now that he's old enough, we want to talk to John. Is there a way to specify that?
You can, because there is an overlap between the financial aspects of the. Yes. The question is, if I have a separate agent for my financial power of attorney and for my healthcare power of attorney, can I direct that they communicate and coordinate in their activities? And yes, you can put provisions in there, special considerations in there that they do in fact coordinate prior to making any final decisions from either a purely financial perspective or the healthcare perspective. It could be in the special considerations, and I would put it in both documents. I would have that articulated in both documents, that you are directing that those agents coordinate in their activities. And they can be separate people, they can be the same person. It's up to you to decide. I think there was a question here. How are IRAs covered? Well, that's an excellent question, because your IRAs have beneficiary designations that you make in them. There are many financial vehicles where we make, as part of our establishment of that life insurance and so forth, IRAs, where you're making a beneficiary designation. That is a contract that you have with that financial organization, and what you need to do is make sure that those beneficiary designations track and complement your estate plan, where the remainder of your estate will flow through, let's say because of things being sold and the remainder of your estate being created that way. You want to make sure that the outcome is consistent with how you want it to be. So that's why I say it's a collaboration between your financial advisor and your legal advisor. Yeah, good question. Yes, right here. I'll answer. That's a great question. I'll answer it a slightly different way. We have gone to great lengths to try to make the portability of those plans work, whether they're created in one state and are brought in and actually executed or used in another, so that there is no jeopardy to your plan. If you've moved, you don't want it undone in a way that's not good. But pursuant to the financial powers of attorney, I would have those done under the Pennsylvania state law. I would have new ones created to ensure that you're getting the recognition of those laws in the state of Pennsylvania. Yeah. Okay, yes, sir. Okay, excellent question. The question is, can the agent in a durable power of attorney continue to pay bills and do things where their name isn't actually, quote, on the account? Now, what we do is we provide specific instructions, and if the instructions in the power of attorney document, typically they cover incapacitation. So when the person is incapacitated, can't write the checks for themselves, then the agent can act. And the agent will act on behalf of that individual, and they don't have to have their name as a joint owner on the account. But what they do, and I recommend you do, is you take the power of attorney document to the financial organization, provide it to them so that it can be on record, so there's no delay in your ability to carry that out, or there's no, questioning about who's signing and why are they signing it. So we set that up in advance so that everything works smoothly, and that doesn't require you to become a joint owner. There's implications both from an estate tax and other capacities about becoming a joint owner of an account that you would want to talk to the financial institution about and your attorney about. If you do that, you can do that, but it's not necessary for the power of attorney. All right. Yes. Mm-hmm. Right, the wrong people. Yeah, it is. So again, just to restate what Kimberly was saying, any changes in your life, you should go back and reflect on how those implicate your estate plan. And take it out every now and then, look at it, make sure that it actually follows your intentions, and it's all synced to your financial investments, beneficiary designations, and so forth, and you'll be well served. And I always welcome calls from agents. It's my policy not to have them worried about it. They want to call me up, they're not going to get a bill immediately, because I'd rather them ask me a very simple question that we take care of in a couple of minutes than to come to me later on and say, how do I get out of this problem? And how do we rectify this? And now it's a lot of work, or we may not have the result we're looking for. So they should work with the legal advisor that you're choosing to make sure that they're carrying out the actions the right way.
Before we adjourn, I hope you're seeing the main topic that we're trying to get forward during this whole seminar, and it's to be prepared. Do it now, don't wait for a week, don't wait for the month, or wait for 3 years, but do it now and be prepared. Now, if anybody's a Boy Scout, that's the motto of the Boy Scouts, and I gotta give a shout out to today. Louis grandson got his Eagle Scout yesterday.
Very cool. Yay. Yay.
So when you see Louise today, she has a special pin that she's a grandmother of an Eagle Scout. So I want to thank Daral for being here today, and thank you for everybody being here. We have 3 more sessions to go, so we'll see you here next week.
Thank you. Thank you very much.
Thank you, Daral.
Thank you.
It was good.
It was. Well, thank you. I hope it covered the bases.
Turn the mic on.
Oh, yeah. Yeah, let's get rid of that. Yeah. Yep.
So what happens if you